Hey, it's me. We're live. Boy, we got a lot to talk about tonight. Give me 1 second. Let me get YouTube refreshed. Let's catch up with y'all in chat. Oh, there's so many new documents to go over. There we go. I think I see myself. Can you all hear me? My microphone does appear to be on for a change. That's a good start. We're off to a good start. So hi, everyone. We got all the mods in chat feeding it. Sarah, Amanda, Cabbage, thank you for being here. I really appreciate the help. Catnit is around. They're all around. So if you need a mod, go ahead and reach out. They're here. Hi, Falcon. I'm glad you made it. Taking a break from gaming. Me too. It's the Diablo 2 Resurrected beta, open beta this week, and I am itching to get back to it. So we have a lot to read. So let's get it done quick. All right, what we're going to do tonight, there's 8 or 10 new filings that we're going to read through. I'm going to skim some of them because a lot are just procedural gobbledygook that none of us understand anyway. But we're going to talk about the context of all of these filings. And then we're going to talk about the new attorney that was added, appointed by the court for Lori Vallow Daybell, Mr. Jim Archibald. Done some looking into his, history and what he does as a lawyer, some of the cases he's defended, things like that. So we're going to talk about him a little bit just to get everyone caught up to speed. So we're going to dive right in. All right, the first document, this is an order by the court. So I'm going to read it. It's up on your screen. Let me make it bigger so you can follow along if you want. There's the button. Can you all see that? I know it's a little bit small on YouTube. Hey, Alex, I'm so glad to see you. Alex, I have been loving your videos. I've been watching all of them, especially the live stream you did about internet toxicity. That one hit home. So thank you for being here. I really appreciate it. If y'all have a minute, maybe one of the mods can find a link to Alex's channel and drop it in chat. If you just look up Alex Erickson, you'll find a link and you can drop it in chat for everyone to go sub to her. All right, so all right, lots of reading. I'm going to skim a lot of the case numbers and stuff like that, but these are all important, so I want to go through them one at a time. All right, the first one, this is an order from the judge, okay? On May 24th, 2021, a grand jury in Fremont County returned a true bill of indictment charging both Chad Guy Daybell and Lori Noreen Vallow Daybell on one indictment, as provided for in Idaho Criminal Rule 8B. Upon consideration of issues raised by counsel regarding defendants' case numbers and administrative proceedings in the case, the court issues the following order. For purposes of conducting a jury trial, the cases of the state of Idaho versus Chad and state of Idaho versus Lori are currently joined. However, for administrative purposes, in order to protect the defendant's full panoply of rights, including due process protections afforded by the United States Constitution and the Idaho State Constitution, each defendant has a unique case and a unique case number. Okay, that makes a little bit more sense. It is therefore ordered and confirmed that Fremont County case number 1623, which is Chad, and 1624, which is Lori. Oh, I've got to move this so I can read it. Oops. Good job. Good job. I'm getting there. Are two separate cases before the district court in Fremont County, Idaho, regardless of the single indictment. The defendants are, however, joined for purposes of trial pursuant to ICR 8B. All right, so what does this mean? Wait, there's one more statement. It is further ordered that counsel are directed to file all subsequent pleadings in each case captioning only that individual defendant's respective case number and name. All right, so what is it saying? They're going to have a joint trial, but their cases are separate, okay? It's not like they're going to be arguing both cases concurrently. They will be, but they won't be. Basically, administratively, right, if Mark Means wants to file something for Lori, that gets filed under her case number. If Pryor files something for Chad, that gets filed under his case number. Keep things a little bit separate and a little cleaner going forward. All right, I've been saying for a very long time that I suspected John Pryor was going to file a motion for severance. We still haven't seen that. Kind of strange, but anyway, that is the first order from the court. So let's move on. Now this one, order for appointment of counsel. All right, now this one's important. Remember there was that sealed order, an order for a motion to seal for the state's objection to an appearance of counsel for conflict, right? And a lot of people had some pretty wild speculations about what that was about. It's not about me. However, this speaks to that motion. So let's read through this. This is important. Okay. This matter is before the court on issues relating to the state's motion in objection to the appearance of Mark Means as counsel to defendant and other proceedings. Based on the record and good cause appearing, this court finds the following. Now, these are the judge's responses or the judge's orders to the motion put forward by the state objecting to Mark Means as counsel. All right, so this is what they were objecting to, and this is what the court has to say. Number one, upon request of Mark Means in case number blah, 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 the court ordered an evaluation of defendant's competency to stand trial. The state raised the issue that no finding of indigency had been made. Okay, defendant explained she lacked the means to pay for the evaluation on May 21st, and the court determined her to be indigent. Okay, there was a lot of speculation about then is why is she indigent? What's going on? Well, it was because of the evaluation for incompetency. All right, so that was the first issue that the state raised with the court. This is the court's finding. Second, on May 24th, a Fremont County grand jury returned an indictment charging the defendant with several crimes, including charges that carry the possibility of the death penalty or life in prison as punishment. Number three, this court stayed all proceedings in defendant's case, CR 22, blah, 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 based on the issue of defendant's competency, and after taking judicial notice of that fact on June 9th, 2021, entering an order staying the case. Okay, we know all that stuff. Next, moving on. On June 8th, 2021, this court found defendant not competent to stand trial and ordered defendant to be committed to the custody of Department of Health and Welfare for treatment. Idaho Code section blah, blah, blah requires the court to presume the defendant to be indigent while she is being housed in a mental health facility. Okay, now, both the Sixth Amendment to the U.S. Constitution and Article 1, Section 13 of the Idaho State Constitution guarantee the right to counsel to persons charged with a crime. Okay, none of us debate that. Statutory protections bolster these rights in the state of Idaho, requiring that counsel be provided to defendants at every critical stage of a criminal proceeding. Okay, we know all that. Further, under Idaho Criminal Rule 44.3, a finding of indigency for defendant to obtain state assistance for the necessary expenses of her representation, coupled with potential penalties of the death sentence on charges against her in the indictment, require this court to appoint a qualified, in italics, trial attorney. There's the big conflict. Now, we've all talked about this for a year and a half. Goodness gracious. So we've been talking about this for like a year and a half, okay, about the fact that if it was a death penalty, could John Pryor and Mark Means still serve as attorneys, right? This is a big conflict. That's most likely what that was about. Now, here the judge goes on to explain. Certainly, the Sixth Amendment also grants the accused personally the right to make his defense, meaning every defendant enjoys the right to waive death penalty qualified counsel and hire their own private representation. However, because this matter is stayed pursuant to a finding that the defendant is incompetent to stand trial and is therefore deemed unable to understand the nature of the proceedings against her and meaningfully assist in her defense, the court is unable to conduct the requisite inquiry to determine whether the defendant may elect to knowingly, voluntarily, and intelligently waive her right to the death penalty qualified counsel at public expense. That's a really important paragraph. What the judge is saying is, if Lori were competent right now, she could say to the court, I don't want a death penalty qualified attorney. I still want Mark Means as my counsel. She would have the right to do that, and the court would hear her arguments and make a decision. But because she's incompetent, she can't say that. So the court is appointing a death penalty qualified attorney on her behalf for now, and then we'll see what happens when she's declared competent. Okay, so that's kind of a big deal. Let's finish up. Further, the court determines that although the case is stayed, ongoing evidentiary issues, including an alleged co-conspirator's concern that DNA materials may be entirely consumed, and that would be Chad Daybell, bear upon this defendant's right to an exhaustive defense of her case. As such, upon consideration of the court's power to control its process so as to make them comfortable to law and justice, in order to uphold a duty to protect fair proceeding and parties in this case, it is hereby ordered that a death penalty certified public defender is ordered to appear in the case under ICR 44.3 as co-counsel, okay, with defendant's privately retained attorney Mark Means. The court finds that there is no need at this time to appoint a second death penalty qualified counsel. All right, so there's that. Yeah, so that's what's happening with that whole conflict, the sealed motion. It was Mark Means can't represent her. He's not death penalty qualified. And I'm saying, well, Lori has the right to waive that if she wants. But the court's saying, well, no, she can't because she's incompetent. So boom, the court has appointed Jim Archibald, well, a court-appointed death penalty qualified public defender to Lori's case. That's all that's what that was about. All right, so I hope we've cleared that up. Kind of a big step. And we're going to talk about Jim Archibald in a little bit, but let's move on to the next filing. All right, here we go. This was the order appointing counsel. Okay, this is just following on from what we just heard. Having previously found the defendant to be indigent, R. James Archibald is hereby appointed as counsel for defendant in the capacity of public defender for Fremont County in this case. The court finds there is no need at this time to appoint additional counsel, and Mr. Archibald is to appear as co-counsel with attorney of record Mark Means in the representation of defendant until further order. Until further order issues, the administrative district judge will address, consider, and order the payment of defense costs. Compensation and payment of expenses shall be in accordance with ICR 44.3. The court clerk is directed to file payment requests, as will be further directed by the court. All filings related to the compensation and payment of expenses shall be sealed, and counsel may file ex parte motions, affidavits, and requests for defense costs arising from the appointment of Mr. Archibald and in his capacity as public defender at the state expense. Okay, so the state appointed him. The state is paying for him. He is a state public defender. All right, so that's what's going on with the court with that. All right, next, I'm moving on kind of quickly. All right, these, I'm not going to read totally through these. There are two of these. There's one for a set for Chad's case and a set for Lori's case. This is more about the discovery battle. You know, there's monster discovery battle going on between the state and the defense. The state said they would have all their discovery by July 15th. These are their discovery disclosures. There's two of them. Saying comes now the state of Idaho by and through the Madison County Prosecuting Attorney's Office and pursuant to Idaho Criminal Rule 16 notifies the defendant of the following. Statement of the defendant. Okay, this is the things that they have turned over. The statements of the defendant, statements of the co-defendant, defendant's prior records, documents and tangible objects, reports of examinations and tests, state witnesses, expert witnesses, police reports. And there you go, on August 9th of 2021, signed by Lindsay Blake and Rob Wood. That's the first one. And the second one, the second supplemental discovery disclosure, same basic thing, documents and tangible objects. Just, you know, going over that, saying, hey, we have turned over all of this stuff. All right, so this is their disclosure to the court, saying, hey, judge, we turned over all this discovery to the defense. Here's a record of it. Okay, so that's what those two filings are for. Alex, thank you so much for the super chat. I really appreciate it. That's adorable. I love that super sticker. Thank you for that support. Much needed today. All right, so moving on. Next. All right, this is the notice of appearance. A very quick document. This is for Lori Vallow Daybell's case. Pursuant to the court's order appointing counsel dated August 6th, 2021, James Archibald Esquire. All right, this is one sentence. You think I could read one sentence without trouble? Let's try that again. Pursuant to the court's order appointing counsel dated August 6, 2021, R. James Archibald Esquire gives notice of his appearance on behalf of Lori Vallow Daybell. That's it. Done. All right, next. Now, this is interesting to me. This comes from also Jim Archibald. Now, this is his request for discovery from the state, but notice how nice and neat and to the point it is. Yeah. Let's read this. Pursuant to Rule 16, Idaho Criminal Rules, defendant requests discovery and inspection of the following information, evidence, and material. Statement of defendant, statement of co-defendant, defendant's prior records, documents and tangible objects, reports of examinations and tests, state witnesses, expert witnesses, police reports, any and all audio and video recordings of the incident, including interviews investigating the incident. Now, if you read back through that list, that's kind of exactly what the state has turned over. Okay, now he wants his own copy of it. So there you go. That's how you do a nice discovery thing. They know what the discovery is. They turn it over. They title it the same way. What's the problem? Okay, I don't see a problem here. I'm sure that he's just asking for his own set of discovery, and the state will turn it over. Nice and neat. Done. All packaged up with a pretty bow on it, you know? And then we come to this. Okay. Declared motion to dismiss the grand jury indictment. There's a couple filings here for Mark Means. This is the first one. All right. Now, this is a motion that he filed to dismiss the indictment from the grand jury. Let's read it, and then we'll talk about it. Comes now defendant, Miss Lori Noreen Daybell, and moves this court to dismiss the ex parte grand jury indictment on or about March 8th, 2021, this court, pursuant to the Idaho 18211 and 18212, issued an order to stay legal proceedings regarding said defendant. Said order from the court said, pursuant to the 18211-212, this case was stayed from further proceedings pending a determination on the issue of the defendant's competency. The order for the stay regarding all proceedings against the defendant was provided and served on counsel for defendant and the state prosecution in this matter on March 8th, 2021. Despite this personal knowledge and notice to the state ignored said order and acted in violation of this order and organized, conducted, and caused to occur legal proceedings against the defendant. There is no plausible argument regarding this blatant violation of the court's order to stay. The supercilious actions taken by the state prosecution in direct violation, contempt of this court's previous orders to stay warrant the issues of a dismissal of the above case and sanctions to be issued against the state and prosecution. Wherefore, defendant rightfully requests this matter to be dismissed forthwith and sanctions, costs, and fees to be issued against the state prosecution. All right. On one hand, I want to say any defense attorney would probably file that in this situation. Possibly because, if you don't file motions to dismiss and things like that, then you have appeal causes later on. But we'll have to see what the judge says. I don't think this has merit. I think the judge will say the grand jury can happen whether or not Lori's incompetent. That has no bearing on a grand jury because it's not proceeding in the case. It's part of the investigation. A grand jury is the culmination of the investigation that, the state shows to the grand jury. They get their indictments and they move on from there. Nothing has happened since the indictment in Lori's case because there's a stay. So I think it's just jibber jabber. I don't expect much to come of this, but that's that. So let's move on to the next one. All right. The third declared motion to compel. Now we've seen this twice already in this case. This has been filed in the conspiracy to conceal and destroy evidence charges case. But now we have this here too. This is Mark Means arguing with the court about wanting sanctions against the state because they have not turned over all the discovery. The state has put forth their discovery disclosures. We saw the list that they made of all the pieces they were turning over, same list that Archibald is asking for. Seems like they're doing what they need to do, right? They gave the court a date. Mark Means filed an objection to that as well. But here we go, another thing. And I'm not even going to bother reading it. It's just la, 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 give me my discovery or sanctions. All right, so, the defendant is requesting a hearing. The first through third motions to compel on the matter as soon as the court is available. Plaintiff be ordered to provide full and complete responses in an expedited manner. Plaintiff be imposed with sanctions by the court for costs, fees, and other appropriate sanctions as the court seems fit, but not limited to a dismissal of the matter. I don't think that the judge is going to dismiss the case because of this third motion to compel for discovery issues. So we'll see what the court says. Let's move on. Next, we have this. Now, we've seen this before. Okay, we've seen this before too. The supplemental declaration in support of motion to compel. This is Mark Means telling the story of when he went to the state. He went to their office to try and get the discovery. He even brought his own hard drive so they could just load it all up and he could go home. And they said, oh, well, you can't get it now. Come back in a couple hours. So he went out for lunch or something, came back in 2 hours, and they still didn't have it. And they called Lindsay Blake on the phone and on. It's just him telling that story again in another supplemental document. We've heard it before. But here he also totals up his fees. Okay, as a result of the discovery request notice above, my notice, failure of any communications by the prosecuting office, my office incurred 11.5 hours of legal fees, minus 2 hours to meet with client, which was not going to happen to production by prosecution had occurred, 728 miles, on and on, with a total cost of $4,346. Okay. Wherefore, said defendant requests this court order the following. Defendant requests a hearing on this matter as soon as the court is available. The defendant further provides notice of reservation of rights regarding this matter, including but not limited to requests for dismissal, Brady violation motion, sanctions, etc. Plaintiff be ordered to provide full and complete responses in an expedited manner. Plaintiff be imposed with sanctions by this court for costs, fees, and other appropriate sanctions, on and on. So there you go. That's another filing by Mark Means, again on the same discovery issue. Now, it looks like the state has turned over the discovery. They put that in their discovery disclosures. We read through both of them. What's the problem? I don't know what the problem is, but this is going to have to be heard by the court, and we'll see what they say. Who knows? So let's move on. Next. All right. Those are all the filings in the court to date. There may be more coming this week. We'll keep an eye on it. But let's talk about Jim Archibald. All right. Now, I hadn't heard his name before. I don't, hang around Idaho to know these people. But Jim Archibald, he was appointed, remember, he was appointed by the court. It's not like Mark Means picked him. The court appointed him. He's a public defender who's death penalty qualified. And because Lori is incompetent and indigent, she gets a public defender, and the court can appoint it for her because she cannot waive her right to a death penalty qualified attorney at this time while she's incompetent. All right. So this is Jim Archibald. Now, what do we know about him? Some things. I've learned some things. So let's talk about it. This is his high school yearbook picture from Bonneville High School, class of 1979. He was a varsity basketball star, I guess. He's somewhere in that picture. Typical. However, somebody sent me an article about him, and I really wasn't sure what to do with the article. Because when I first read it, I'm like, that's not really a valid news website. It's, written very opinion-like, but let's find it. Here we go. This is the first thing that I read. All right. And I read through it, and I'm like, I don't know if this is true. All right. So I'm going to tell you right here, I don't know if this is true or not. This website certainly is sketchy, I guess. But I did find another article backing this up. All right, so let's read through it. So while sitting as a magistrate judge in Idaho Falls, okay, I didn't know that Jim Archibald was a magistrate judge for a little while. He was accused of being drunk in public and groping two women at a juvenile drug court conference in Florida. Judge Archibald continued to sit on the bench for an additional 6 months after the charges were lodged against him, but resigned 2 weeks before his probationary period ended. Archibald had the chutzpah to claim that he resigned due to depression and the pressure of being a magistrate judge. Okay. And it just goes on with this stuff. Now, when I first read that, I'm like, that's curious. Right. And so I decided to see if I could verify it or disprove it, because this is not, this isn't CNN or any kind of news website. But I did find this, the Spokesman Review. And this was back years ago, and they do highlight the same thing. Basically, the members of the Regional Commission charged with selecting magistrates, let me make this a little bit bigger so you can read it. Okay, members of the Regional Commission charged with selecting magistrates in eastern Idaho say his record over 18 months on the bench worked to offset the misconduct charges against James Archibald, who resigned just 2 weeks before his probationary period ended. If there would have been reason to take him off the bench immediately, that would have happened, said Madison County Commissioner Roger Muir, a member of the Magistrate Commission for the 7th Judicial District. Okay. Muir did not attend the May 12th meeting at which the commission, primarily composed of local elected officials, narrowly voted to keep Archibald on the bench, despite the allegations that he was drunk in public and groped two women at a juvenile drug court conference last year in Florida. But other commission members who were at the meeting spoke to Post-Register in Idaho Falls on the condition of anonymity, citing Archibald's solid record since he took the bench in January 2003 and expressing concern that his accuser did not appear. He has refused to comment on the charges. His resignation on June 16th occurred as the Idaho Judicial Council was considering the complaint. The council handles disciplinary actions against judges and magistrates. One commission member who supported Archibald's dismissal told the Post-Register that since the commission hired him, it was responsible for dealing with the allegations. Under the magistrate law, regional commissions filled vacancies appointed, and then review and selection is after 18 months. Magistrates who clear probation must then stand for retention by voters at general election. All right, so is this an issue? I don't know. It does sound like it did happen, okay, because this is... we can find it on at least one semi-regular news sort of source. But, I don't know how big of a deal. It's certainly not like the issue we saw with John Pryor, but it's just something to keep in mind. Okay, so this is something that happened apparently back many, many years ago, 2003, 4, 5, something like that. So, that's the history. However, there's something else about his case that's a little concerning. So let's talk about that. There we go. Hi, I'm back on the screen. Okay, so now I can see chat again. We're done reading all the documents. But I want to talk about another case that happened in Idaho in 2015, 2016. This was the Tanner Cox case. All right, Tanner Cox was a young guy who had a road rage incident with someone. And he chased the other driver down, and the driver got out of his car, and they had a fight, and he decked him, right? Punched him, knocked him out, and the guy fell to the ground, hit his head, and then passed away, unfortunately. Tanner Cox went to trial, obviously, and he was sentenced for, what was it? It wasn't murder, involuntary manslaughter. Okay, he had a 5-day-long trial, convicted of involuntary manslaughter, was sentenced to 10 years with 2.5 years that he had to serve, so eligible for parole after 2.5 years. And his lawyer was Jim Archibald. All right, and his lawyer pled with the court that, he shouldn't go to jail. Jail's going to make him a bad person. He can be rehabilitated. Let's not give up on him, and don't just throw away the key because he can be saved. And this is where a lot of people have issues with defense attorneys, because that's what they do, right? This man that was killed left behind children. Both of his ex-wives testified on the stand about what a great man he was and how hard his death has been on his family and children. And it was Jim Archibald, or Archibald. I guess a lot of people want me to say Archibald. Whatever. It was Jim Archibald who defended him and got him that very, very light sentence. Is that concerning? A little bit, honestly. If you want to find more about the Tanner Cox case, let me put a link. I'll put it in chat so you can go read up on it. It's from East Idaho News. You can read a little bit more about the case. I've done some talking to people that know Jim, talking about his personality, how his family is very connected, all this stuff. So is he a horrible person? I don't know. I don't know him personally. His record, he is a death penalty qualified defense attorney. He does defend murderers or people alleged of committing murder and serious crimes. And he seems to do a really good job defending them. So if that's cause for concern, but there you go. So that is the story of Jim Archibald. You can find a lot of his record online. Just do some Google searches. I'm still looking into the allegations that were levied against him when he was a magistrate judge, because if you can only find 2 sources on the entire internet, and one of those sources is a very questionable site, you got to take it with a grain of salt. It may not be true at all. So I have no idea, but it's something to talk about and look into a little bit more to see what's going on. Now, the big question is, when Lori is competent again, what's going to happen? Will he stay on the case? Will she waive her right to a death penalty qualified attorney? Will she keep him? Will she fire Means? Who knows what she's going to do? However, the judge does have some leeway to discuss this and make his ruling on it. So I think it'll be okay. I do. Let's see. Let's catch up with chat. I haven't really read chat while we're reading all of this stuff. Oh, hi, Jenny Stern. How you doing? Hey, Karen. It's good to see you. I'm glad to be live. There hasn't been too much in the case. Last week, all of these filings came out, but my husband was on vacation, so we were doing family stuff and house stuff. We had a really great staycation week, and couldn't be bothered with YouTube because it was, I don't get a chance for him to be home for a whole week very often. So I was focused there. Hi, Janine. How are you doing? I'm glad you're here. Oh, man. All right. So those are all the filings that we have. I don't have too much more on Archibald Cox, but I do have some conversations going with people that know him personally. So let's see if we can find out. Susan says, I'm not worried about Lori escaping justice. Neither am I. I'm really not. I'm pretty sure, they did file the notice to seek the death penalty, even in her case, for when she is out of the hospital and restored to competency. So, there you go. I'm pretty sure that's going to happen. We don't anticipate any big issues, not sure how else to say that. I don't think she's going to get out of jail ever again. So there's that, whether she has this guy or not. So there you go. Oh, talking about text, but Latin. Are we speaking Latin in chat? That's fun. Something I've always wanted to do is learn Latin. Not very easy to do nowadays. But, all right, so do you have any questions about any of the documents that we read through today? There's quite a lot of them. But they're all, all the discovery things, we've been talking for a long time how annoying this discovery battle is, because we have the state saying, here's our discovery disclosure, we turn it over, here's the dates, everything, and the defense coming back and saying, no, we want all the stuff. And the state saying, we gave you all the stuff, here's some more stuff. It's back and forth, it will not stop. Kat Stallsworth, hi, how are you, Kat? I'm glad to see you. So glad to see you back in the Mystery Voice. Oh, thank you. I'm glad to be back. I was really glad to have that staycation, though. That was wonderful. I needed that for sure. Oh, Emily Flotilla, that's a really good point. She's still, once the Idaho cases are wrapped up, she still has to face the charges in Arizona. Remember, they've said here, we're ready. We've got the indictment ready. Just going to wait and let Idaho do their thing first. So, yeah, that's good news. Oh, hi, Lisa Discovers. Glad to see you. Yes, the Arizona stuff. Also, if anyone still needs the 2,500 pages of the Chandler document dumps, let me know. I did have them uploaded to a shareable link thing, but I think that's expired. I think so, but I can upload that again. If you still need it, just let me know. Hi, Robbie. How are you doing? Oh, goodness. And Christine Isabel. All right, so there really aren't, a lot of questions about them because they're pretty straightforward. Can Mark Means rep Lori in Idaho, Arizona? No, he cannot. He cannot because he's not a licensed attorney in Arizona. I guess he could go to Arizona and try and pass the bar to do that, but I don't think he would. I don't know. But yeah, she'd probably need a public defender there because if she's indigent in Idaho, she's still indigent in Arizona, unless she's got piles of money stashed somewhere that we don't know. So yeah, he cannot, at least right now. Yeah, but I think the documents that we read certainly cleared up the sealed motion objection to the notice of appearance and conflict that was filed by the state. We'll not get to see that. It is sealed, but the court did address the issues in the order that we started off with. So now we can pretty much know what happened there. Not a big mystery anymore. Goodness. All right, so I'm going to keep watching the case, of course. Yes, I'm still going to cover the case, but I only do videos when there's actual news. Like if there's some new filings or something happens in the news, then I'll make a video about it. I don't tend to just do random videos every couple days just to keep them going, because why? We all have better things to do. So when there are more filings, I will do more videos. And I prefer to do live streams, but sometimes I just don't have the time to do that. Chad and Lori won't do much time in prison. They both get jailhouse justice. I don't know about that. But I don't think either of them are going to be walking out in the fresh air ever again. So there you go. All right. So that's pretty much all I have for you tonight. I'm just looking for questions to see if anyone had any more questions about the documents we read through or anything that's coming up. Yeah, speculation is fun, but it isn't my thing, because a lot of the speculation going on, certainly a lot of it about me, is horrible. And so we don't do that here. But plus there's plenty to go on just with some of the stuff in the court. My goodness. This case is crazy enough. We don't need to add to it. You're welcome, Chris. Thank you for being here. All right, so I will keep my eye on the case. What am I expecting next? There is technically a hearing tomorrow morning for Lori from Madison County. It should be a pretrial conference. However, there is a stay in that case. I do not expect that to happen. I will watch the judge's YouTube and see if it actually happens, but it shouldn't, because there's a stay in the case. So if anything happens tomorrow morning, I will let you know. I don't think it's gonna, though. So we'll find out. And welcome, Mo Beans. Glad to see you here on the channel. All right, so I'm going to get Diablo 2 Resurrected Open Beta. I have one more day to play, so I really want to get that done. because it's a ton of fun. Discord is still closed for the time being. There's a lot of people there, but we'll redo invites probably next week. Get a new link for everyone so you can come and join. All of the documents that I read through today, they are available in Discord. They're up on the court website. If you need a copy, just email me and I can send them to you, or at least get you a link where you can download them yourself. But all the PDFs are up in Discord. So they should have vacated it for all of us who followed. Yes, they should have, Jenny Stern. They absolutely should have. So... Yep, D2 open beta. Yep, it's really good, Robbie. It's a lot of fun. It's really cool. All right, so thank you to all the mods, especially last minute Catnet. Thank you so much for being here. And Cabbage, I really appreciate you joining us. And I will talk to you all soon. If you need me, you know where to reach me. Bye for now. As soon as I remember how to turn this off again. Here we go. Good night.